So first, let's talk a little bit about the powers and responsibilities of the board, the general role the board of a nonprofit plays. So under the Model Act, it states that all corporate powers must be exercised by or under the authority of the board of directors of the nonprofit corporation, and the activities and affairs of the corporation must be managed by or under the direction and subject to the oversight of its board of directors. So what that all boils down to is that it's the role of the board to direct the course of the corporation, to make sure that it's effective and efficient at furthering its mission and its stated exempt purposes, to make sure it complies with all applicable legal requirements, and it's the role of the board to kind of oversee the corporation's activities and its performance. So you should think of the board as having ultimate oversight responsibility for the affairs of the organization. The board also has the responsibility to protect the public's interest in the nonprofit. So because nonprofits are tax exempt, because they're not paying income tax, and because we allow donors generally to make contributions to the nonprofits and to take tax deductions for those contributions, society has a collective interest in how these nonprofits operate, and we're entrusting the board to oversee society's interest in that nonprofit. The boards also generally should review and approve the financials and the budget for the organization, make sure that the organization is financially sound and has secure financial plans in place. The board should also make large strategic decisions for the organization regarding its operations and decisions that have a significant financial impact or a significant impact on the organization's mission. And then just a note about composition of boards of directors, which may be impacted by the state of incorporation and any rules under that state. Some states may only actually require a minimum of one director on a nonprofit board. California, for example, only requires a board to consist of one individual. But even if that is legally permissible, we typically recommend that any organization that intends to apply for tax exemption under Section 501c3 have a minimum of at least 3 directors. The reason is that the IRS tends to be a little bit skeptical of an organization that has fewer than 3 directors because there might be a higher risk of the organization's assets being used to improperly provide a private benefit to somebody. Now, states might also have rules about the composition of the board, such as the 49% rule in California. And what the 49% rule says is that no more than 49% of the directors on a board's on an organization's board of directors can be compensated by the organization or related to someone who's compensated. And the idea behind that rule is that they don't want the directors to be stuck between determining whether to use the organization's assets to compensate themselves or to use the assets to further the organization's exempt purposes. So they want a majority of the directors to be disinterested or not compensated by the organization. So it's important to be aware of any other applicable requirements that might apply under state law based on the state of incorporation. So now let's talk about the duties that a director owes to the organization on whose board it sits. And this will be applicable to attorneys who are advising nonprofit clients, but also to attorneys who serve on a board of directors for a nonprofit. So I'm going to do a little bit more reading from the Model Act here. The Model Act says that each member of the board of directors, when discharging the duties of a director, shall act in good faith and in a manner the director reasonably believes to be in the best interests of the nonprofit corporation, and that the members of the board of directors or a committee of the board, when becoming informed in connection with their decision-making function or devoting attention to their oversight function, must discharge their duties with the care that a person in a like position would reasonably believe appropriate under similar circumstances. That's a lot of legalese, but it basically boils down to the main fiduciary duties that a director owes to an organization. And those main fiduciary duties include the duty of care and the duty of loyalty. And then the duty of obedience is arguably a third fiduciary duty that a director owes to an organization that's helpful to acknowledge just for practical purposes. So let's look at each of these. So the duty of care comes from the language that I just read from the Model Act that requires a director to discharge her duties with the care that a person in a like position would reasonably believe appropriate under similar circumstances. So what does that mean? It generally means that a director needs to obtain adequate information in order to make informed decisions. So the director should request appropriate materials related to the actions that she needs to take, should ask questions of the staff, the officers, the other board members in order to get the information that she needs, should be familiar with the organization, including its legal structure, its governing documents, such as its articles and bylaws, its stated exempt purposes, its activities, and its key stakeholders. It means that directors should actually review the materials that are sent around in advance of a board meeting and be familiar with them in advance of the meeting. And that a director should exercise independent judgment in making decisions. You shouldn't want a director to feel intimidated or afraid to speak her mind at a board meeting, and boards should generally seek to foster an environment that encourages respectful dissent among directors. Basically, you want directors to actively participate in meetings and not just to rubber stamp decisions on behalf of the organization, which isn't doing the organization any favors and probably isn't living up to the director's fiduciary duties. Now, in exercising the duty of care, a director is typically entitled to rely on the information, opinions, reports, and statements that are made by or performance by certain people. And those people include officers, employees, or volunteers of the organization who the director believes to be reliable and competent with respect to the particular information. They also include legal counsel, of course, since lawyers drafted the legislation, public accountants, or other experts that are retained by the nonprofit if the matters are within that person's expert competence and as to which the person merits confidence. And finally, a director can rely on information from or performance by a committee of board members as to which the director does not sit on and which the director believes reasonably merits confidence. So the bottom line here is that a director is entitled, in carrying out her duty of care to the organization, to rely on the information that's provided by other people in the categories that I just mentioned, but that reliance can't be done blindly. It needs to be done in good faith, and it needs to be warranted when the director actually relies on that information. The duty of care also doesn't mean that the board has to engage in all the activities for the board or for the organization. It doesn't mean they need to do everything themselves. And a director can actually delegate the management of the day-to-day activities of the nonprofit to certain other individuals, including officers, committees, volunteers, or staff members. And this is pretty common in nonprofits. Often you see the day-to-day management of the affairs of the nonprofit delegated by the board down to other individuals. But the ultimate oversight of the organization needs to stay with the board, and all the activities of the organization need to be under the ultimate authority and direction of the board. So the board can delegate day-to-day management, but it cannot delegate oversight. And I'll just here make a quick note about committees. So the Model Act provides that a board can create committees at its discretion. They can be standing committees or ad hoc committees. They can be composed of a wide range of individuals, and they can be tasked with a wide range of responsibilities and authority. But the Model Act also distinguishes between two types of committees. The first is board committees. Now, board committees must be composed solely of directors. They can't have anyone sit on them who's not a director. They can permit other individuals, such as an executive director or an officer or staff member, to attend the meetings of that committee, but they can't actually be a member of the committee. And board committees, if they're composed solely of directors, can be tasked with the authority to act on behalf of the board. So a good example of a board committee is an executive committee that might be authorized to act on behalf of the board in between board meetings and to make decisions for the organization. Now, the other category of committees that's permitted under the Model Act is referred to as other committees or advisory committees. And these committees can be composed of individuals who are not directors. They can include, outside members of the public or key donors or other various stakeholders. And these committees can actually be tasked with a significant amount of responsibility and authority, but they can't be authorized to act on behalf of the board or to make decisions that the board should be making. So the bottom line is that directors, in exercising their fiduciary duty of care, can delegate a significant amount of authority to other individuals or to committees, but they should be sure to prudently select to whom they delegate such authority. They should carefully define the scope of the delegated authority, and they should exercise oversight to ensure that such authority is appropriately exercised. All right, now let's talk a little bit about the duty of loyalty, which is the second fiduciary duty that directors owe to a nonprofit. And this duty comes from the language of the Model Act that requires a director to act in good faith and in a manner that she believes to be in the best interests of the organization. What that generally means is that a director owes an undivided allegiance to the corporation. They have to put the interests of the corporation above even their own interests. It also means that a director can't misappropriate a corporate opportunity. So that means if a director becomes aware of an opportunity that the nonprofit may be interested in by virtue of its operations, she should make that opportunity known to the nonprofit and give the nonprofit the first chance to go at that opportunity before taking advantage of it herself. It also means disclosing any possible conflicts of interest, and I'll talk about conflicts of interest in a little more detail in just a moment. It also means abstaining from any votes where a potential conflict of interest exists, and also maintaining the information of the organization that should be kept confidential. It should be particularly appropriate when boards are dealing with sensitive information about the organization. Now, I just mentioned conflicts of interest. The Model Nonprofit Act defines a conflict of interest as a contract or transaction between a nonprofit and one or more of its members, directors, members of a designated body or officers, or between a nonprofit and any other entity in which one or more of its directors, members of a designated body or officers, are directors or officers, hold a similar position, or have a financial interest. And what that basically means is that a conflict of interest is a situation in which a director has an interest in a proposed transaction to which the corporation may be a party. Now, conflicts of interest are not rare, and they're generally also not prohibited. They may actually even be in the best interest of the organization. So, for example, if a director is offering services to a nonprofit below market rate, that may be something that's in the best interest of the organization to take advantage of, even though it may provide a financial benefit to that director who owns the outside business. So, from a legal perspective, what really matters with respect to conflicts of interest is how they're handled. And that's what's going to determine whether a duty of loyalty has been breached. So when a conflict of interest potentially exists, it means that the director with the potential conflict should disclose to the board that the conflict exists and all material facts, that the transaction involving the potential conflict of interest should be approved by a majority of the disinterested board members who don't have a potential conflict of interest with respect to the transaction, and that the transaction should be fair and reasonable to the corporation at the time it's entered into. It's important to note, too, that even a perceived conflict of interest or an actual conflict of interest may also have potential PR consequences for an organization. So it's something the board may want to think through before approving a potential conflict of interest transaction, even if going through the process it determines that it's permitted to enter into the transaction. As I mentioned earlier, it's also very important for nonprofits to have a conflict of interest policy in place and to ensure that they actually follow the terms of the policy and that it's updated regularly if necessary. Conflict of interest policy also might require directors, officers, and certain key employees to sign a disclosure and provide certain information to the nonprofit on an annual or other regular basis as to any potential conflicts that they may have with respect to the organization, which can be helpful for the organization in keeping track of any potential conflicts of interest that may arise. Now, the third duty, and I mentioned, is not technically a legal fiduciary duty, but it can be helpful to acknowledge for practical purposes, is referred to as the duty of obedience. And what this basically means is that a director has a duty to ensure that the nonprofit on whose board she sits carries out the corporation's purposes, that the organization complies with all applicable laws, and that the board and that individual director refrains from engaging in any activities that are beyond the corporation's or the director's powers, called ultra vires activities.